Mr. Speaker.
I call the Honourable David Parker.
Thank you, Mr. Speaker. Mr. Speaker, this is an important bill, notwithstanding the fact that the last speaker just stood up and took a 5-second reading. Any bill that affects the civil liberties of New Zealanders and actually gives powers of surveillance to an arm of the state is worthy of proper consideration by this House. And that's true whether it's the police, whether it's the Customs Service, whether it's the Ministry of Transport, or whether it's the New Zealand Security Intelligence Service. And this bill affects the powers of the New Zealand Security and Intelligence Service. Those powers of the Security Intelligence Service have not been updated for some years now. Indeed, the Principal Act was enacted in 1969, which is 41 years ago. And in that time, technological changes have meant that there have been significant changes in surveillance techniques. And this Parliament has been addressing the consequences of those changes in surveillance techniques in ranges of pieces of legislation recently, notably the Search and Surveillance Bill, which deals with police powers and the other powers of non-state agencies. We've touched upon them in respect of private security personnel, although that's an area of law that still needs a bit of a tidy up. And now Parliament's looking at it again in respect of the Security and Intelligence Service. It is a sad fact that one of the things that's happened as a consequence of change in technology is that there are methods of surveillance in New Zealand that are currently able to be used by arms of the state that are largely unregulated because they weren't thought of at the time when the original pieces of legislation controlling state activities were passed by this Parliament. So rather than these pieces of legislation necessarily always conferring additional powers on state agencies, in some ways they limit the powers of state agencies to use these new technologies in a way that is currently unconstrained. So the Labour Party agrees that there is a need to tidy up these new technologies and make some other changes in respect of the Security Intelligence Service, just as we agreed that some changes were necessary in respect of the police and other state agencies and in the search and surveillance legislation. Mr. Speaker, I'm pleased to talk also about the principles that should underlie our consideration of issues such as these. When we give powers to the state, we should always be aware that they can be abused. And therefore, whilst it's appropriate that the arms of the state have more powers than ordinary people to conduct surveillance operations and to check on illegal activity or plans that could cause physical harm to people, to their bodies, or on occasions be involved in criminal activities or activities that threat the security of our company, we must always be aware that unconstrained powers to state agencies should be avoided because these powers can be abused. We see that not just in New Zealand but in other countries where it is entirely appropriate that we in this Parliament put limits around the exercise by state agencies of the powers that they need on occasions and which go further than the powers that I have or anyone else has in this House to maintain surveillance operations on other people. We don't have these rights as private citizens generally, although there's some holes in that law at the moment as well, but generally we don't have those powers. And when we give those powers to the state agencies, we ought to be sure that they're appropriately constrained. Now, there are different sorts of constraints that you have in respect of the police compared with those which you give to the security services. The security services does have different methods of oversight. The oversight in respect of security warrants is provided by the Commissioner of Security Warrants, who is a retired High Court judge. That person is of higher standing than the person to whom you normally apply for warrants in respect of police matters. Police can get warrants from registrars of the court, from justices of the peace, and that sort of level of disclosure to what we would describe as lower level functionaries in the state bureaucracy is not always appropriate in matters of state security. And so for that reason, in respect of the Security Intelligence Service, the person who oversees the issue of warrants is a retired High Court judge. The changes that have been proposed to the Act have been advised by the government to the opposition, and we thank the government for the briefing that they provided to the opposition in respect of the reasons for these changes. That follows on a tradition that's long-standing in New Zealand and is to be applauded, because these things ought to be done with cross-party support if at all possible. We have already made the point through Annette King, the Honourable Annette King, in this debate that we think that there should be a public process for hearing submissions. When we confer rights on state agencies, we ought not to be scared to hear from people who might be critical of those decisions. They could be right. We ought to hear their submissions. We ought to take into account their submissions before we in this Parliament decide to change the powers of the Security Intelligence Service. Now, there will be times where the justification for powers such as these that are sought might include instances of where these powers have been used previously that the Security Intelligence Service think it's appropriate that members of Parliament learn about, but they don't think it's appropriate that it be advertised through the newspapers effectively if there was public reporting of that. And that's a delicate balance for Parliament to tread, because we want to maintain as much openness as possible, but at the same time we don't want to be so open that we actually inhibit the fair operation of the Security Intelligence Service, or make it more likely that they won't be as open with the Select Committee as we would hope they would be. Now, that balance is to be struck by the Select Committee, and the Select Committee is in charge of its own processes. So the chair of the Select Committee and the members of that Select Committee have an important task to consider whether some or all of these submissions that are heard on whether all of these submissions should be in public, or whether there are some selected submissions that are appropriately heard in private or in secret. And there are precedents again for this, and the Right Honourable Jenny Shipley previously said under the National-led government in 1999 that considered some changes to that considered Security Intelligence Service matters, that these hearings should be open to the public unless there are extraordinary circumstances that require a closed hearing for any particular submission. And I suggest to this House that remains the position. And just because we've had at one level a rise of terrorism internationally since that period, it doesn't change that underlying principle that there should be something extraordinary that would justify a Select Committee doing these things in anything other than a public way. If I say where I think some other countries have gone wrong in other parts of the world, I think that some of the additional powers that have been conferred upon state agencies in terms of surveillance powers in the United Kingdom have, in my view, gone too far. And there's considerable backlash against that in those countries. And of course, if you have a backlash against arms of the state, you're actually undermining public confidence in the rule of law, because you actually want to carry people with you when it comes to the laws that govern search and surveillance. You want people to think that the system overall is fair so that they cooperate with it rather than work against it. So we don't want to make the mistake that I think has been made in Great Britain, where search and surveillance powers of state agencies have gone too far. We want to maintain the civil liberties that we have, to have freedom from inappropriate intrusion by state agencies into our lives, whilst not being so naive as to think that there aren't, or to deny the reality that there are occasions when we want an arm of the state, the Security Intelligence Service, to actually be checking whether there are some people doing some things that could be damaging to our country's interests. Mr. Speaker, the Labour Party supports this bill to Select Committee, but as we will be keeping a weather eye on the process at that Select Committee to make sure that all that can appropriately be done in public in respect of this legislation is done in public. Thank you.